have a little more of a complete list of bills that will be in our conference committee. And Chair, if that works for you, we will go ahead and have the revisers give us a rundown on everything that we've got. We can talk about those when we get to them. Thank you. Jason Thompson, our reviser, and I suppose maybe Natalie Scott's going to help too. Yep, thank you.
All right, thank you, Madam Chair. So you have a little larger document this time. There are still a handful of Senate bills waiting for concur or non-concur. They're not on the list yet, so I won't cover those, but just FYI, those are out there. So there may be a third version of this still to come.
Thank you, Jason. We did do 4 on the floor this morning,
They're
and they're on here, but there are some additional. Okay, thank you.
I can tell you those numbers if you'd like to know them, which ones are still waiting, but I didn't put them on the chart.
Sure, I think that'd be helpful.
Okay. So the ones we're prepared to add, but have not added yet are sub for Senate Bill 54, Senate Bill 186, Senate Bill 204, Senate Bill 237, and Senate Bill 241. And then we have House Bill 2164. It's the only House bill, and I forgot about that one. So that's potential additions. I mean, unless you concur, then we wouldn't add them, obviously.
Right. So those 6 aren't in conference committee.
Not yet, no. They're awaiting action to concur or non-concur.
Thank you.
All right, so Senate Bill 30 is the first one on here. This is a fingerprinting and background check bill. As it left the Senate, it was to add the Secretary of Labor to receive certain information from the KBI relating to background checks, and then amending a statute requiring employees that have access to federal tax information received directly from the IRS to be fingerprinted and submit to the background check. And then the House amended that bill to add several provisions from another fingerprinting request. The first 3 statutes are all relating to the bank commissioner, and they're sort of just effectuating the changes in the background check provision. So I won't go into detail on them, but they're definitions and changing the way those statutes are worded so that you go to KSA 224714 to do those background checks. And then Section 4, the background check statute itself, is the same as what passed the Senate, but with the additions of the Attorney General receiving certain records, and the State Gaming Agency receiving certain additional records, and then the State Bank Commissioner being added to the statute. And then there's a companion amendment in 757B01, which is the private detectives statute, to go with one of the AG changes. And then the final section is the same as Section 2 of the Senate version with no change. So that's kind of tracking what came to the House and then what the House added. I noted that this one, the Senate did non-concur this morning. They're awaiting House action to accede. So it's not officially in conference completely. You couldn't act on it today, but you know, we can talk about it. So the next one then would be Senate Bill 84. This one is fully in conference. You non-concurred and the House acceded, so you're all here. This is the one that modifies criminal use of financial card to include gift card related crimes. You can see there's no difference except the House changed the effective date to Kansas Register. So, simple. Senate Bill 135 then. This is the one about precedents of child-related orders issued under the Protection from Abuse Act, the one from the Judicial Council group, I believe, sort of clarifying and making that language a little bit easier to read, more user-friendly. You'll note there's really only one difference. We made a technical change to number the paragraph. We missed one. So paragraph 1 is numbered in the House version, and that's the only difference between the two. That one is still awaiting House action. The Senate non-concurred this morning, so the House will need to accede or take some action. Senate Bill 156, creating the crime of unlawful use of a laser pointer. This is a new crime, and the only difference is the House changed the effective date to Kansas Register. Again, Senate non-concurred this morning, awaiting House action to accede. Senate Bill 157, search warrants issued only on the statement of facts. made by a law enforcement officer. That is what came from the Senate. What came from the Senate was the underlying provision, making a copy of warrants available to compensated sureties, directing forfeiture to be set aside if you can prove deportation, and remitting 95% of the appearance bond if returned within 180 days after judgment. Hopefully you kind of remember that one. What the House added were the provisions of two other bills. So first, Senate Bill 138, that's section 1, statement of facts sufficient to show probable cause made by a law enforcement officer, not any person, as the statute says now, I believe. So that again is the contents of Senate Bill 138 as it left the Senate with no changes. Section 2 is the same as the Senate bill that came to the House, but some changes. 14-day requirement does not apply to the court. It is upon request, so sort of at any time, the surety can make the request of the court. There's no time limitation on either party. The deportation provision was modified to apply only when the defendant was not held subject to an immigration detainer when the bond was posted, and the surety can prove the defendant has been deported. So there's a little more to that provision than there was in the Senate version. And then finally, the 95% remittance provision was changed to a 3-tiered provision. 90% if the defendant's returned within 90 days, 75% if returned within 91 to 180 days, and 50% if returned within 181 to 270 days. So that's the major changes from the Senate version that passed over. And then finally, the House added another Senate bill to this bill. That's Senate Bill 244. No changes from that bill. It's the one that prohibited a compensated surety from making a loan for certain portions of the minimum appearance bond. Again, awaiting House action on that one. And then we're to the House bills. I'll turn it over to Natalie.
Thank you, Madam Chairs.
Just a moment, Jason, I had a question. You talked about 244 waiting House action on 244 because it passed out a, tell me about that. $157 is on our list in the chart though. I thought you said there were 6 we were waiting on action and this wasn't one of them.
Right, because you non-concurred, it's on the list. And we're just waiting.
Okay, they haven't.
Yeah,
Okay.
take their side of the action, right? The ones that aren't on the list
Okay, I
have
see.
not been concurred or
Okay.
non-concurred. So we didn't feel it was appropriate to assume you would non-concur.
Correct. Okay, thank you.
Okay, on to the House bills. The first House bill you guys have in conference is House Bill 2062. We kind of went through that one this morning, so of course I can take any questions you have about that one. House Bill 2134, that's a bill about the Open Records Act. The way it came over from the House, KSA 45219 was amended to include review and redaction time and the actual cost for furnishing records when an agency is charging for an open records request. It also requires the agency to use the lowest cost category of staff when they're furnishing those records and to base the charges on their salary or their hourly wages, not including benefits. It also requires agencies to make efforts with requesters to mitigate cost if the open records request is going to be over $200. And finally, it requires or it provides that if the requester doesn't respond within 3 business days to those efforts to mitigate costs, then that request is deemed withdrawn. Over in the Senate, the only change was they added a provision that on request, the agency is required to provide an itemized cost statement to the requester that includes the hourly rates charged for each of the employees that are involved in making the request. On to House Bill 2155. This bill amends KSA 19811 to provide that sheriffs have liability for official acts that are related to their charge of overseeing jails. The Senate only changed the effective date, so that's the only difference there. House Bill 2183. This is the provision, those 3 crimes, adding AI-generated material to those three crimes. Section 1, 215510, this is sexual exploitation of a child. So it includes possessing artificially generated visual depictions, and then it defines artificially generated visual depiction and obscene. And then in KSA 215611, which is the crime of transmission of a visual depiction of a minor, it adds in that definition items created by artificial intelligence, regardless of whether the child was created or involved in the creation of that visual depiction. And then finally, in breach of privacy, KSA 216101, it includes disseminating items created by artificial intelligence, regardless of whether the subject was involved in creating them. Over on the Senate side, they kept everything largely the same, except in the breach of privacy provision, they added an exemption for direct-to-home satellite services and multi-channel video programming distributors. Next one is 2242. This bill amends KSA 27102 to allow the federal government to request the state take concurrent jurisdiction over land that's owned by the United States for military purposes. When it came over to the Senate, the only change was changing the effective date. House Bill 2347 changes the culpability requirement for certain types of theft. As it left the House, all it did was change known or having reason to know that the property was stolen and the culpability requirement to commit theft. The Senate added a provision which is similar to the way it was introduced to make theft of a motor vehicle a severity level 10 non-person felony. But the Senate added if it's a value of at least $500 but less than $1,500. And then finally, 2371 is the LLC bill. So essentially it updates the Kansas Revised Limited Liability Company Act, the Business Entity Transaction Act, and the Business Entity Standard Treatment Act, essentially to conform with Delaware, but then it also made the changes to the series LLC provisions, and the only change the Senate made was the effective date. And I can take any questions on those.
So the list you gave us this morning is included in the second list. Okay, just making sure that there wasn't anything I needed to be looking at again. Okay, thank you. Okay, does anyone have any questions for the revisers on any of that? Okay, seeing none, we'll move on. So the House gave you this morning some language that we wanted to add to 2062, or change, I guess. I'm sorry, is it 2062? It's 2062. Okay, thank you. And I'm just wondering what your position is on that.
Thank you for the amendment this morning, and you can imagine it's been a busy morning with being on the floor for some time and other conference committees to attend to as well. So just haven't had an opportunity yet to confer with leadership of our chamber and see what their thoughts are. And I think actually we were waiting for a couple of answers regarding some definitions in the amendment. So I think Adam was getting those and he's not here, but maybe we have those answers. Yeah, I think we're going to check with revenue and see what that looked like. And maybe the definition or the answer to Representative Osman's question.
Okay, if you would go ahead, please. And we believe that the question had to do with the definition of stillborn and those stillborn statutes and anything about those that would be applicable here. Okay, sorry, Representative Osman. Mhm.
No problem. Thank you, Madam Chairs. The question specifically was what is required to get a certificate? That was the baseline question, is what is required to get a certificate?
All right, so Madam Chair, we reached out to our health folks, and so the definition, so this is in the Vital Statistics Act, that's where these provisions are. So the main thing is you have to meet the definition of stillbirth, which, as we talked about, has a 20 weeks requirement. So I'll just read the definition of stillbirth. So that the main thing is that this definition has to be met, and then there's a certificate that has to be issued by a medical professional. So the definition is stillbirth means any complete expulsion or extraction from its mother of a human child, the gestational age of which is not less than 20 completed weeks, resulting in other than a live birth, as defined in this section, and which is not an induced termination of pregnancy. So that's stillbirth. And if that happens, a medical professional is required to provide one of these certificates. So that definition is in 65-2401. And then in 65-2412, that's where the stillbirth certificate's required for each stillbirth that occurs in this state. So understanding that a physician or a physician assistant or somebody like that, a medical profession like that, would basically be the one to do this certificate. And then those certificates are filed with the state registrar. And I think that was about all we had on that sort of process.
Yep. So I do have a question. It's my understanding that getting the stillbirth certificate is voluntary. So you had mentioned required. Would that be required if the mother asked for that certification? Because it was my understanding when we put this statute in place, I think it was like 2014 or something like that, that it was voluntary if you even got the stillborn certificate. Do you have any info on that?
So Madam Chair, I was familiar with the 2014 change. That's KSA 65-2440. That's the one that required the state to establish these certificates. But from all of the research we were able to do, it looks like if you are in a medical setting and the medical professional acknowledges that a stillbirth has occurred, they are required to create the certificate to file with the registrar. So I don't know that it's necessarily at the option of the patient at that point.
Representative Osman.
Thank you very much, Madam Chair. And thank you very much for the explanation. I realize we're just at this point hashing out definitions, but I'm concerned about this definition or about this procedure as it's presented in here. Under the current system, somebody would get a certificate of stillbirth for personal reasons. There are a lot of personal reasons why you might want to do that. What we are attempting to change in here is to get it for financial reasons. And that is a huge modification. If somebody wanted to commit fraud, they could try to get a certificate of stillbirth 2 times a year for the foreseeable future, and that would be allowed under law. And how do we stop them? On the flip side of things, for those that are not looking to defraud the government, but this is, again, a very personal issue that happens to them that they are looking to create a certificate for, and they do not do it properly. They don't file it properly. The timeline doesn't match up. Again, these are wanted births that they now need to go through the government intervention to try to get a tax exemption for. Are we going to have parents with wanted children that through mismanagement of government forms are indicted under tax liability or tax fraud? Because that's what we're looking at for something like this.
Yeah. On on a certificate of live birth, or it's on a stillbirth, it's just like a birth certificate or a death certificate that has to be signed off by somebody that's regulated. Is that correct?
Madam Chair and Senator, yes, I mean, our understanding is it, just like a certificate of live birth, it has a seal, it's an official state form, it's signed by a medical professional, all of those things.
At that point, we don't have a lot of, these other areas are regulated. People are putting their medical license on the line by fraudulently creating those. So I'm not sure it's worth what would have to be gained for a $2,000 personal exemption in these situations. Just to, there are other checks on the vital statistics system. So just to share my two thoughts.
Any other questions? Senator Corson.
Thanks, Madam Chair. Couple questions. I mean, one is, it seems like, and we talked about this on the Senate floor, it seems like we've gone from a bill that was purported to be about child support to a bill that is now basically a little bit of child support, but mostly a tax bill. So now we've kind of moved away from what the initial purpose that it was purported to have, and made this functionally kind of more of a tax bill. So that's my first question. And then my second question is, I think, is the intention of this, is it to have 2 exemptions for a child who's 0 to 1? Because I think I'm struggling with the point of this amendment, because if you have a live birth, you are already getting a tax exemption, and that's already here. And so you get a personal exemption of $2,320 for each dependent for which such taxpayer is entitled. So, is that the purpose? Is that you get a double exemption from 0 to 1, and then from 1 to 18 you go back to 1 exemption? Was that the purpose of you offering this? Because we already have that for live births, is my understanding.
Yes, that's exactly what the idea was, because as you know, this bill with the amendment passed the Senate floor 30-9, I think is what it was. And so, but looking at the red tape that would ensue after a tax identification number on an unborn child and so on, this was a way to more easily do what the Senate passed, but without the red tape. And so, yes, so the first year, there's kind of a bonus exemption that kind of goes back to that year of pregnancy. So yes, it's kind of a double exemption during the first year. And then from then on, it's just the one time, as always. And I kind of would disagree that now it's become a tax bill, because I mean, yes, we have added that piece on there, section 4, but in section 1, 2, and 3 do have to do with child support, and that is the base bill. Any other questions? Okay, seeing none. Representative, or I'm sorry, Chair Warren, did you have any other thoughts?
Thank you, Madam Chair. I would say that with the clarification from the discussion this afternoon, that something to discuss with our side further before we can provide a response.
Okay, so I think our next step is figuring out when we can meet again.
Or I would suggest, since we've had an explanation of other bills that are here in conference, if you would be amenable to looking at some of those or not. And I was thinking specifically, 2347.
Okay. So I do think we have lots we can do, and I think it will be easy. I do know the House is having calendar right now, and I have to do a concur, so they could be waiting on me. I'm not sure where we're at with that, but
Apologize, I did not realize that our caucus for 1:30 had gotten canceled, so I figured we would have some additional
Oh,
time and
okay.
could do some additional work. But sure, let's set a time to meet again.
okay. I think we're going back on the floor at 2, and then possibly again at 4, but I don't know that we'll have something to do so soon after that.
So I think we're
What's
still
your
going back
thoughts?
on the floor at 2 and 5.
2 and 5. Should we try for 3?
I think so.
Okay.
3:30? No, you have to go back on at 4. 2:30?
Yeah, we could try for 2. Yeah,
2:30.
let's try for 2:30. Right? Everyone okay? Okay, then back here, I think we'll be able to get the same room. Hopefully tomorrow we'll get a bigger room is what we're shooting for. But back here at 2:30, Jordan, you'll let folks know. You'll let the
That's
powers that
only
be.
50 minutes from now.
Yes.
Should we do the second recess of the second chamber? Are we?
You have transportation at 3. We could say 3:30. Let's say, what if we said 3:30?
All right, we'll do 3:30.
Okay. Okay, with that, we're adjourned.